This is Michael Cowan, and welcome to Trial Lawyer Nation.
When the jury panel comes into the courtroom and the bailiff says, "All rise," I know we're here.
And it doesn't matter who they are, nobody should be above the law.
A lot of us talk about that, but you've actually done it.
That's how you also maintain quality control over your practice.
Yeah.
That's a question I get asked a lot, and here's the answer.
Welcome to Trial Lawyer Nation, your source for guidance to win bigger verdicts, get more cases, and manage your practice. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowan.
Today on Trial Lawyer Nation, we have Mark Kosieradzki. Mark, how are you doing today?
I'm doing great. How are you?
I'm doing well. Thank you for joining us today. Now, you've written more than two books, but you've written two books more recently. 30b-6, Deposing Corporations, Organizations, and the Government, and you have one that just came out today, Deposition Obstruction, Breaking Through. Is there a common theme to these books?
Well, one of the things I've learned is our society, and particularly the litigation society, has kind of evolved into win at all costs. And there's cheating, and there's hiding, and there's obstruction everywhere in this world we call litigation. And it was really kind of, when I was growing up, my dad, taught me that, if you cheat to win, you really didn't win. And it's kind of a theme that I've had with me. And over the 40 years of practice, I've taken on all kinds of giants, from multinational corporations to mom and pop shops. And I've learned that rather than trying to win their cases on their merits, they try to win by hiding information. So my books have been focused on how to cut past the nonsense. As Jim Morrison said, break on through to the other side.
Yeah. What motivated you to dedicate so much of your practice to, because we all deal with it somewhat, but it takes a lot of effort and time to break through stuff. I think a lot of people just give up and settle.
Well, I guess, I grew up kind of scrappy. I have a family history of scrappy parents. They're immigrants. My mother was a freedom fighter in the fall of Warsaw, fought in the Polish underground. She was captured by the Nazis, went to a concentration camp. My father was a Polish soldier who got swept up by Stalin and went to a gulag in the north of the Arctic Circle.
Wow.
And then they immigrated. When they got out, they went to Italy, they went to school there, and then they came to the United States. And so from birth, I was taught to stand up for principles. And, we joke that I was genetically bred, to be a street fighter. And so, from when I was in sports, I was scrappy. But then when I got into the practice of law, I had to view it, from another angle. And a lot of great mentors along the way at these conventions took me under their wing and shared things with me. And I started studying and learning how to use the rules to win legally without cheating. And I can go home at night feeling a lot better.
Yeah.
And the practice of law is a lot less stressful if you know the rules of engagement. Because you can just say, let's let someone else decide, and all the huffing and puffing doesn't do anything.
What did you do, I guess, to learn the tools that you needed to break through and use the rules to get to the truth?
Well, it started by having my backside handed to me many times. One of the sayings I teach my children is, Dad has got a lot of wisdom, and wisdom is what you get when you didn't get what you wanted. And so a lot of it was trial and error, because there weren't people who really dug into the law. Back then, they used to say, I don't do legal research. I'm a trial lawyer. Well, I learned that that's a good way to lose cases, because the best football players, the best basketball players are the ones who know the rules, and they know how to use them. And so I started studying through a lot of the AAJ programs, and then I got involved in the faculty, and then ended up teaching with programs with all kinds of organizations and learning more and more. And the more I learned, the more I realized this isn't that hard. If you play by the rules, you can force the other side to play by the rules.
So what are some of the techniques you've learned, first of all, to figure out when are they actually hiding something from you?
I just start with the premise that they are.
Okay.
You know, if you see things like objection, but without waiving, I'm going to give you everything, that really is code for saying, I'm going to give you everything that doesn't hurt us. When people use qualifiers in their answers in a deposition, that means they're hiding things. So what we've learned and what I've learned, and I've developed techniques on this I've written about in the 30B6 book, is we first want to gather the universe of information that's publicly available. And my God, you know, you can find anything on the internet. I found out that it was colder in Minnesota yesterday than it was on Mars.
Wow.
You know, it was
Nice to be in Miami today.
yeah. And so there's lots of things you can find, and then you got to actually read it and study it, and then see how the known information comes together. Then you start seeing what makes sense. You know, they call it common sense, but you know, you really do. Does this story make sense? And I try to find out, does our story make sense? Does the other guy's story make sense? From there, then we start thinking about what is the universe of information out there that our adversaries would have. They could be documents. They could be other testimony, electronically stored information. I learned this in a civil rights case 30 years ago, that the key to the case was electronic. And I get that information first, because then you can control people with the documents.
It is amazing what you find when you dig. We had a case recently where the truck driver was texting and driving when he hit our client. And he had a prior write-up for texting and driving. And they said, well, how did that happen? Well, we have like a cam system that when certain decelerations happen,
right,
and I hit a pothole and I happen to have it in my thing.
Right.
And that was their story. And so we compelled the video. And what he was doing is he was on his phone, in the middle lane, the left lane got a green arrow and started going forward so they can turn left. He sees that out of the corner of his eye. He goes forward, hits the car in front of him. So he actually had a prior crash. The two videos, their crash and our crash, look identical. But had we just accepted their story, it would have been, well, I hit a pothole, I was disciplined,
I'm not going to say everybody's a liar, but I have found that when people are backed into a corner and they're going to be held accountable, it's amazing how many people will create a truth in their own mind so they don't have to accept responsibility for what they did. And it's been my job to always find that out. And typically what we find is we always want to find out what happened. We want to find out why it happened, because the why is the critical part. And when people start hiding the truth, that becomes the perfect storm.
Yeah. And why is so important, because when the jury understands why they did wrong, then they understand what they need to do to fix it. Exactly.
That's because what happens is everybody makes mistakes. And we live in a society where they say, well, stuff happens, so we're not going to just drag someone in the courtroom in there. But if we structure this as to what it really is, that someone has made some conscious decisions. They made a conscious decision to fudge on their medical records. They make a conscious decision to understaff nursing home. They make a conscious decision to make a trucking company driver drive longer hours or without training. That decision making puts everybody else at risk. And what happens is, if the juries understand that, then they're motivated to follow the law to hold the wrongdoers accountable.
So, what are some of the tools you use then when you've got an inkling that they're hiding something from you? What are some of the tools you use to discover that and to break through and get it?
Well, the vast majority of my adversaries are institutions. And since they're institutions, I can use Rule 30b-6, which is a deposition by designation. Rather than saying, I want to depose Joe, I want to depose the corporation or the organization or the partnership or the government and say, you pick whoever you want. I don't care. I want to know this information. And I tell them what I want to know. And through that, I can craft concepts to force them to disclose information. But before we do that, I got to force the disclosure of their electronic information or their documents or their histories, because they're not going to be forthright in telling us. Then once we do that, I have to deal with the games that the litigators do. The litigators are the people who want to hide evidence. There's a big difference between a trial lawyer and a litigator.
Right.
A trial lawyer wants to tell a story. A litigator wants to hide evidence. And so I use tools to extract that through depositions, and there's a whole series of different kinds of depositions we can talk about if you want.
I would love to, yeah. That's because one challenge I face, and I've gone back and forth between trying to compel all the documents before I do any depositions, or get what I can and then take a deposition so that I have some evidence, because it's hard to go. They don't necessarily. The lawyer in the courtroom is not necessarily lying to the judge when he says, as far as I know, these things don't exist, because they haven't told him.
Right.
He might not have asked, but they haven't told him.
Exactly.
And so when you're going there and you're asking a judge to compel something without proof that it actually exists, it can be tough. But then you take the deposition, you prove that it exists, then you've got to convince the judge to let you redepose somebody or depose somebody else. So how do you approach that?
Michael, you're spot on that. And I've actually evolved some new techniques in the last 2 years on that. I find that despite the prohibitions of boilerplate objections, they're universal. What's your name? Objection vague. It's so what we have now done, and this is going to be kind of a long answer,
right?
We start with a lot of case analysis. I mean, we storyboard it. We put all of our information in buckets of information, and then say, what is it we're trying to accomplish? And we start with the assumption, and it's nothing but a theoretical assumption, that one person could provide all information. We structure an outline of what that one person who knows 100% would tell us. We work it and rework it, and then we identify what documents in electronically stored information would support any one of these principles. This is still case analysis. Then we create what would be a request for production. But we don't serve that, because we're going to get boilerplate objections to everything, even though they're illegal. So what we do then is we create a 30b-6 designee deposition with a schedule of documents in it, but we don't request the documents. We say, we'd like someone to provide all information known to the organization about what documents exist in this category. What's the retention destruction policy? What is the purpose of these documents? Because that creates relevance. How are the documents shared so we can determine if these are legitimately confidential or not? Because if there are no protections. And then the important part is, where are they located? How are they organized? And what are all the available methods of search? We haven't asked for anything. All we're trying to do is create a record so that we can design the most proportional and efficient way to get the documents or the electronically stored information. And now what we've done is we've preempted all the boilerplate objections before we ask for them.
And do you get any pushback that that's trying to do discovery on discovery, or?
That's what it can't be discovery on discovery because we haven't asked for the documents yet.
Oh, wow.
We're not asking for their search. So the discovery on discovery is tell us how you did this search. We're not asking that. We're saying what are the ways it could be searched for so we can ask the most economical way to do it. And what's beautiful about this is if you read the amendments, the 2015 amendments to the federal rules, to Rule 26, the big proportionality amendment, in the committee notes, the Rules Committee said this very thing I'm talking about is so well entrenched in our jurisprudence, it doesn't even have to be in the rule anymore. And they talk in terms of custodial depositions to identify how to craft the search. And I talk about that in my book.
That's a great idea.
And then once you say, get this, you make the request and they say, vague, well, no, you've already defined it. How do you define a personnel file? It's this and this. How do you use that term in your business? Okay, we're going to use that term. What's the purpose of it? We use it for X, Y, and Z, so now it's relevant. How do you share it? We share it by email. Does it go on a blast email? Everybody in the company gets it. Do they have to sign confidentiality agreements before you send them? No. Is there any tools in there? No. To hide it? No. How hard is it to look for? Really easy. We just call it up on the computer. How about if you want to print it? Push the print button. Anything overburdensome about that? No. But now all of those objections, which they will make, you can respond with a meet confer letter that here's the record of your own person. Therefore, you don't have a factual basis. I'm requesting that you withdraw the objection and give us a complete answer. Now they've got a problem.
Yeah. Now, that is a wonderful way to practice, but it's very different than just, okay, I've got a nursing home case, so I'm going to call someone who's done a nursing home case, and I'm going to get their stock depot notice and request for production and send out what they did.
We'll return to part 2 of this podcast in just a moment. Each year, the law firm of Cowan Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide. Are you an attorney with a catastrophic injury or wrongful death case you'd like to discuss with host Michael Cowan? If so, you can reach Michael by calling 210-941-1301 or send an email to michael@cowanlaw.com. We now return to the rest of this episode of Trial Lawyer Nation.
How do you structure your life where you have time to go and storyboard and plot out a case and then take this deposition and then craft? How do you do that?
Just say no to cases.
Okay.
We turn down 6 to 8 cases a day. We pick our cases carefully, and then we work with smaller caseloads. That's the one part. And what I've learned is I used to be a volume lawyer. I'd have 250, 300 cases. I was just flying by the seat of my pants all the time. My stomach hurt. I had ulcers. The skin would come off my hands. It was horrible. And I didn't know the rules, so when defense lawyers would yell at me, I'd think they were valid. What I learned was, and the model that I had been taught before was, well, you got to get as many cases as you can, and then you settle them because there's a fixed value on it, and you want to get that fixed value as quickly as you can with as little work as possible. And I bought into that nonsense. Well, that assumes that the other side decides the value of the case. What we've learned is they don't fix the value. They've got to come up with a number that will make me go away. And we found that by putting more work into the good cases, our hourly return actually goes up, We've worked on it a lot more, but the case gets a lot bigger because we prove the case and we get the evidence. And that's the important part, is getting the evidence.
I found the exact same thing. We, at one time, and I kind of inherited a law firm. I had a person I went to work for as a young lawyer with 3 weeks' notice decided to become a public defender. And I ended up with a firm on my own way before I was ready to have one. But I used to have over 200 cases just for me. 3 legal assistants, me, no other lawyers.
Yeah.
Not a good way to practice. Most of them weren't huge cases, and we managed, but... and then over the years, and then we went down to like 80 to 100 cases per lawyer, and now we're trying to be like about 20 cases per lawyer, and maybe getting lower than that. And I found the fewer cases each lawyer in my firm has, the more revenue each lawyer in my case generates.
Right.
Our settlement values have gone up. The time from intake to settlement has gone down. The satisfaction of being able to be a craftsman, of actually doing good. There's just a satisfaction to doing it right, to finding the stuff has gone way up.
Michael, you've hit it spot on. You really have. And it's really the personal satisfaction that makes you feel good about yourself. And I've been practicing law now, this is my 40th year, and I'm not going away because I enjoy it. And I didn't enjoy it when I was running by the seat of my pants all the time because I didn't feel good about myself.
And it's just having enough belief in yourself and getting rid of the fear that if you tell somebody no, like I have almost all referral lawyer-based practice, and it's amazing that the more I tell people no, it's almost like a challenge to them. I said, no, I don't do these kind of cases. I only want to do this kind of case. And the conversation I have with one of my guys, like, you and I are working on this paraplegia case together. This is a big case. If I take this other case that you want me to work on, that's time I'm taking away from the big case.
Right.
And so there are hundreds of other lawyers. 10 years ago I would have loved that case. There are hundreds of other lawyers that is a big case to them, and they would run with it. And you and the client are better off working with them. And I haven't lost my referring lawyer to those other people.
Right.
And if anything, he still comes to me, and then I said, well, here's a young lawyer I met. I bet this lawyer would do a good job. Or, I don't like marginal automotive product cases anymore, but here is somebody that does them, and they're good at them. And we still have the relationship. I haven't lost anything. Right. It's just getting rid of that. It was all in my own head.
Well, as you speak to relationships, the other big piece is if you have more time to communicate with your client will like you more and trust you more. And if there's a problem with the case and you've shared that with them along the way, then they'll trust you. And if you say no to a bogus offer because it's a better case, they will trust you. Because that communication builds everything.
I agree.
And they'll send cases to you. And you know what? If you do this, you know who else will send cases to you?
Defense lawyers.
Exactly. Because it's a lot more important to be respected than loved. And when their mama gets hurt, they want someone they respect.
Yeah. One of the things you mentioned, I'm just kind of going back, is one of the things you do in your planning is storyboarding a case. And I don't know that all of our listeners have seen what storyboarding is. So can you explain what is a storyboard a case?
Well, the process is what you ultimately want to do is talk about what your story is going to be to the jury and how do you focus the jury to consider the information that's important in your case. A lot of important information processing theory, and a lot of people have written about it. Neil Fagenson has, Cusumano and Wenner have written on it. Rick Friedman's written on it. Carl Bettinger, David Ball. They're all fabulous resources. And I don't just subscribe to any school. I try to learn all of them because we're professionals. It's not a checklist practice.
Exactly.
When they zig, we got to zag. And so, I'm a blues harp player. When I turned 50, I took up the harmonica. And you learn riffs. And you got lots of different ones you use. And if you're playing with someone and they pitch something to you, you know what to jump into. And we get a lot of riffs for our trial practice, for depositions, for storyboarding. So what we do is we start first with a very simple thing, chronological, beginning to end. But that story is not always the most persuasive one. because the jury and any listener will start focusing on whatever they hear first. So we don't want to focus on our client. We want to have them focus on the decision making of the wrongdoer. And if I can share a story with you,
Yeah, please.
There was a lawyer. You know, you've never met him, but you know him. He's a transactional lawyer, 3-button suit, wears gray ones and blue ones, white shirts only, lace shoes. Big firm, goes to work every day at 8, leaves at 5, no matter what, like clockwork, takes the same route every single day. When he gets to work, he has a sequence of things he does. When he gets home, he and his wife have cocktails, and he goes to bed at 9. And he's been doing this for 20 years. And one day he does something really crazy. It's a beautiful Friday afternoon, and he's done with his work, and he decides to go home at 2:30. And not only that, he's going to drive through the park to do it. And as he's driving through the park, sunny afternoon, carload of drunk teenagers blows the intersection, hits him, and kills him dead on the spot. And we're talking tragedy here. And at the funeral, everyone's talking about, God, what a horrible thing. If only. If only what?
If only he hadn't left work at 2 o'clock. If only he hadn't taken a different route. If
Exactly. And Neil Feigenson wrote about that in Legal Blame. 92% of the people blame the lawyer for leaving work early and don't blame the drunk drivers for going through the intersection, because the focus was on that information availability principle. If the story is retold, there's these kids who skipped school and they stole a bunch of beer, and they were driving through intersections and cutting nuts and got drunk. They're doing this all day long, and at 2:30 in the afternoon, their luck ran out and they hit a car and killed the man. And at the funeral, everyone was talking about what a horrible thing that this fine man was killed. If only.
Yeah, if only those kids had gone to school, if only they had drank,
Right.
if only the parents
And
had...
so that's an information sequencing thing. So we storyboard the case to focus on the decision making of the wrongdoer, and we bring up the plaintiff at the end. And then when we tell the case, then we start taking it even further. Through whose eyes do we tell the story? From a bystander watching it, from someone who knew that they were driving, from the kid's standpoint. You know, and the story can be told 5 or 6 different ways, 100 different ways. And that point of view makes a difference. I mean, Spielberg does it all the time. Who's telling the story? And it's really powerful. So that's how we storyboard.
Awesome. Thank you. Going back to the breaking through, so we started with you do your deposition to find out what to ask for and what exists. You request then the information, documents, electronically stored information.
I know I talk about what they are first,
Right.
In a deposition. I don't request them.
That's what I'm saying. Yeah, that's what I was trying to say. I didn't quite get it right. Yeah, you find out through the deposition. You establish what exists, what it's called, why it's relevant. Then you request it. Then you make them give it to you. What's the next step?
Well, the next step now is you actually read them.
Okay.
It's amazing how many people do discovery and that they don't read the answers to the interrogatories or the documents, but they're just checking it off.
I've done some auto product cases, and back when, now it's all electronic, but he said, back when they used to get 50 boxes, and then as part of the settlement you had to return them, they said like half the time they come back, and the tape was still on them, they had never been read, never been opened.
So after you read them, you analyze what you have to do. And now, usually that deposition, the first time out, doesn't work, by the way, because 30b-6 requires an organization to provide all information known or available to the company. And so they have to prepare the witness, and they seldom do. So there's a whole structure we talk about in my seminars and in the book about how do you ask the questions to establish that they are or not prepared? Who are all the witnesses who have information responsive to this question? What are all the documents that are responsive to this question? What is the ESI? And what has the organization done to make sure that witness has that information? So, because then you'll often find that they're not prepared. So that means you have to start over.
Yeah, what I find is it's someone that has nothing to do with whatever happened.
Right.
Often someone who's a professional testifier, and then has only read the documents that were produced to be in the case and not any other documents.
Right.
Hasn't, has maybe talked to one or two people, but usually somebody within their legal department, and then you just get someone that's parroting the company line.
Like this, there's a case called Kosieradzki. I believe it's out of Mississippi, maybe Alabama. I've got it in my book. And that was a professional testifier that was only prepared to talk about the defense side of the case and not the plaintiff side. Court was unhappy with them, sanctioned them $850,000, and the 11th Circuit affirmed it.
Wow.
So you need to know those rules. But so once you get those documents, now you structure what is the information you're trying to get. What do you really want? Not any and all, everything on earth, and then the week before trial I'll try to figure it out. No. Hunt with a sniper. Know what you're looking for, and start crafting these questions in your deposition notice. And don't say, let's get it off the listserv, because every case is different. And what I find that sometimes we spend 2, 3, 4 days writing the notice for a 4-hour or 7-hour deposition. But once you've thought it through, you get the stuff and you don't have as many depositions. And you have to ask the questions in a way to make sure that they've got the right person, which the cycle goes again. And, that's a 2-day seminar of everything you've got to do. But you can structure your questions to prove that they're not ready. Don't lose your temper. Don't lose your cool. Just set it up that you can prove that they're cheating. And then say, you need to bring me someone else. You got your bite at the apple. So I respectfully disagree. I'm asking you to bring someone else. Bring your motion, counsel. Fine. I've got a 25-page, I don't know, I didn't look, nobody looked, we didn't talk to anybody. I'm the person with most knowledge and I know 2% of the information. I very seldom find a judge who's tolerant of that. What their judges aren't tolerant of is me asking one question, getting mad, and coming in and saying, I want you to rule on it.
Right.
No, I need a long, vetted record with clear sound bites. Did you look in this drawer? No. Did you look in this book? No. Did you talk? Who's in charge of it? Sally. Did you talk to Sally? No. Did anyone tell you what Sally would have to say? No. And you boom, 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 and you prove the case that they didn't prepare. Now you get an order. And it's a lot different when there's an order. People fudge on the rules, and judges historically don't sanction people for that. But with an order, judges get rough.
Yeah.
A case called, I believe it's Pioneer Drive versus Nissan out of Montana. The judge says, you don't follow my order, you go to jail.
Wow.
I like that case.
Yeah, I do find that judges can. It's one thing when they're playing games with you. It's another thing when they're playing games with the judge.
Well, there was that case in Texas, the Fuqua case, where the judge had litigation-ending sanctions for people not following the judge's order.
There's a case you had. You've had a lot of big verdicts, but one that's I think really interesting, and maybe you could tell us a story of how you use these things to get to justice in that case. Boswell versus Sheppard County.
Oh yeah, that was 30 years ago, but it still is something I'm really proud of. I got a call one day that a woman was Native American and got picked up accused of a DUI. Whether she had DUI or not was not relevant. What happened was she was pregnant, and they put her in jail overnight, and she started delivering a baby. And they wouldn't call a doctor. And the baby was born breech and died. There was all kinds of litigation nonsense, and I just didn't like it. I was pissed. I mean, you don't do that to anybody. It was just wrong. So I got involved on this case, and we litigated it for years, and I had a 6-week civil rights trial in federal court. We went to the circuit twice. The U.S. Supreme Court denied cert on it. We were the first case ever to apply 1983 to a detainee because she hadn't been arraigned yet. So they said, you don't get 1983 because she's not a prisoner. And the circuit said no. So once they couldn't win on that, then they said, we didn't know that she was delivering a baby. And this was pre-electronic information as we know it today. The jailer had something known as a telex. And we got into the telex, and we found that they had sent this telex, it's kind of like a fax, to another jail saying, we've got this woman in jail, and there's an outstanding warrant for her for the heinous crime of ricing without a license. It's gathering wild rice. And it's $100 or $75 or something. Do you want her? And the response was, and in that telex it said, she's pregnant and bleeding. And they said, Springer, we'll get the money later. We don't want the medical bills either. Well, they kept her anyway. They didn't call a doctor. At one point when she passed the plug, she's holding the blood up to the camera, showing them, begging for help. They still wouldn't let her go. And ultimately, this baby was delivered and died. Oh. And so then their defense was, well, the baby would have died anyway. It was 27 weeks pregnant. And so we had to prove all of these things, including, that the baby would have been viable. And once we proved all that, the defense lawyer offered me $30,000 and said, why are you spending your time on this? This is just a drunk Indian. And I got madder than hell.
Because the only way you can defend it like that is you don't value the other person as a full
right,
human
I'm saying, and I used some, colorful son of Polish immigrant language.
Good.
And I walked out on the mediation and said, I'm going to call the judge and tell him you're not mediating in good faith. I said, you go for it, big boy, and I'm going to tell him what you just said. And we tried that case for 6 weeks, and the jury was motivated, and at the time it became the biggest verdict ever for the death of an infant. I mean, today it wouldn't be as big a deal, but 30 years ago it changed everything. And as a result of that case, women get doctors in jails.
That's awesome.
And detainees get 1983 protection, and I'm proud of that.
Yeah, absolutely. 30 years ago, I was excited because I got a job where I got a raise from $3.35 an hour to $3.50 an hour. So, money.
I started at $15,000 a year as a lawyer.
Trial Lawyer Nation, in partnership with Trial Guides, leader in continuing education for civil plaintiff and criminal defense trial lawyers, with books, DVDs, CLEs, live webinars, and more. Visit trialguides.com and use code 30B619. That's 30B as in beta 619 at checkout to receive 10% off Mark Kosieradzki's products. This Trial Lawyer Nation discount includes 30B6, deposing corporations, organizations, and the government, and Anatomy of a Personal Injury lawsuit. This discount expires August 31st, 2019. And now, back to the show.
So you've got a new book that's actually just launched today. You're here at the AJ seminar in Miami. You're having a book signing tomorrow after your talk. So what's this new book you have about?
Well, it's about deposition bullies. They're deposition bullies masquerading as lawyers. And we've all seen them. They yell, they scream, they obstruct. They tell you you can't ask questions. They do speaking objections to coach their witnesses and really try to get you off the game. Thomas Pynchon said, if they can get you asking the wrong questions, they don't have to worry about the answers.
Yeah.
And that's what they're trying to do. And I think it's nonsense, and I think it's stressful, and I think it's unprofessional. And I've encountered a lot of them over the years. And it made my stomach hurt a lot. I'd get angry, and I'd dread going to the depositions, and took all the fun out of it. And so I started studying the law about what you can and cannot do in depositions, and how do you view it. And I developed a technique, learning from the great Muhammad Ali, the rope-a-dope. Rather than engaging with them, rather engaging with the slugger, I became a strategist. And I just let them go. The more they object, the happier I am. And then they think you're weak, and they keep doing it. And once I've got 400 objections, then I recess the depo, and they yell and scream and say, you got your bite, you're never going to get another depo. I said, well, let someone else decide. And you highlight every time your adversary is talking, 40% of the time. And I attach that to the motion. And I've never had a judge not get upset with the adversary. If I go in and say, I'm going to call the judge, or we have one objection, and one ruling on the objection, well, the judge is going to rule on the objection. I want him ruling on the conduct. Because you got to be playing the long game. But to be able to know what to highlight and what to ask, you've got to know what the rules are. And so the book will talk about everything is really viewed through two lenses. And it's really easy once you understand that. Lens number one, can you do this in court in front of a judge and a jury? Can you just go up to the witnesses across the examination and say, don't answer that, I need to talk to you, and whisper them in the air? Not a chance. Can you yell at your adversary in the courtroom? No. Can you say, we're taking a break because I need to tell them how to answer the question? No. You can't. If you can't do it in front of a judge and jury, you can't do it in the depo. So then, you say, well, wait, what about objections? Well, there's a second lens. The second lens is it something that can be fixable? You hear form and foundation. Form is this the type of question that wouldn't be able to be asked in trial, and therefore it's an objection to it, and you fix it? Or does a witness have the knowledge, Rule 602, do they have the knowledge to say, I saw the car go, or the car ran a red light, objection, foundation. Simple questions. Were you at the corner? Could you look at the intersection? Yes. Did you see what happened? Yes. Tell us what happened. It's fixable. And then the final thing is, if someone's misbehaving, you say, please don't make suggestive comments in the presence of a witness. Boom. If you understand those two things, let them run, and then show the judge.
Yep. And whenever you get mad, you're letting them win.
That's right, because you can't get sucked into the vortex. They're trying to get you to ask the wrong questions or get off your mojo. And the more you stay cool, the more angry the bullies get. But we used to teach our kids as bullies in the schoolyard. It's easy to be tough. All you got to do is be stupid. The hard part is to be tough and stupid. Know when to stand up, when not. And if you know the rules of engagement, it's actually quite pleasant, because you know that, they're being abusive right now, but you're Ali on the ropes for 6 rounds, taking the blows, and in round 6, in the rumble of the jungle, with one punch, you got a knockout. And that's what you got. You take it to the judge, and you get a knockout. And if you have lawyers who do pro hoc vice, and if they get an admonishment, you've just put them out of business, because you can't get pro hoc. with an admonishment.
The other thing is, if you don't do that, if you take the bait and you're raising your voice and you say things that you shouldn't have said because you're upset, I mean, not only does it take you out of your plan for the depot, but then the judge looks at, I have two lawyers that are acting like children. I just don't want to deal with either one of them.
Exactly. And that's why you got to take the high ground. It works.
Yeah, absolutely. You have a great quote on your Trial Guides website, or the Trial Guides has like a page on you, and it's, as my parents taught me, and I share with my own children, look for and pursue the opportunities to do something meaningful and keep life exciting.
Spot on. And my dad taught me that, and I really believe it. And it's in every aspect of your life. It's in your work, it's in your relationships, it's how you deal with people. Do things that are meaningful to you, and be exciting. And don't be afraid of adventure. Don't be afraid. If you go through life in fear, you might as well just lock yourself in a closet.
And this has been great, but you can only, we can't go on for 2 or 3 days on a podcast, unfortunately. And you teach a lot. If people want to, first of all, if people want to get your new book, where do we get it?
The deposition obstruction book is from the AAJ. They'll have a website on it, or you can call them, or I can give you the link for it.
We'll have the link in the show notes.
Okay, then we'll have the link to the AAJ book. 30B6 was published by Trial Guides, which is another great publisher. They've got fabulous books, all of Rick Friedman's books and Carl Bettinger's book. Serious books I encourage everyone to read. And there's a link on that. You just put in Trial Guides 30B6 and boom, it pops up.
And you said that you teach seminars and stuff on this book?
I do.
How do people find out about that if they want to go to one?
That's a good question. I try to limit myself to one a month.
Okay.
I get invited to do it I could do one every week if I wanted to, but I kind of want to have fun in life.
Yeah.
Doing other stuff
do you
too.
put on your own, or do you just speak at other people's events?
No, just other people asking me to do it. I speak every year at the Advanced Deposition College in New Orleans with AAJ. I usually speak at the AAJ conventions, and I've spoken in, I believe, now 38 states at the trial lawyer conventions. I have one coming up in Utah. I'm speaking to the railroad lawyers in Sedona. I just got asked to do the Arizona trial lawyers. I just got asked to do the Massachusetts trial lawyers. So they just locally promote them.
Well, I really recommend to you, something I do locally is put on your own one day, where it's just you talking for a day. You'll be surprised. I was scared when I first did it that nobody would show up. But you learn and can share so much more when you can control, you're not limited to 30 minutes or 45 minutes. You can really teach a lot.
Yeah, you're right. And I've actually done full-day programs. I did a full day for Vermont last year and a full day for Oregon last year. And it's, you're right, a full-day program is, this stuff is like drinking from a fire hose. My law clerk brought his civil procedure book in, and it had a page and a half on 30B6. My book is 500 pages, 900 footnotes. We do 2-day programs on that. He brought in a civil procedure book on depositions, and I couldn't find anything on it. So we got a 250-page book on all the jurisprudence of deposition conduct. This new book was designed for people who not only to teach them how to do it, but it's written in a way that you can pull the paragraphs right out of the book and drop them right into your brief. So it makes life a little bit easier and less stressful if you've got more cases and you don't have time to write those motions. You can write the motion in an afternoon now.
Yeah, that's awesome. Thank you for doing that.
It's my privilege.
And if somebody wants to get a hold of you to talk about a case or to strategize or consult with you, how do they find you?
They call me. It's the Kosieradzki Smith Law Firm, causlaw.com, and I literally have people calling me or emailing me every day. It's I feel really privileged to have had the opportunity to empower people. And at this stage of my career, empowering people not to be afraid and empowering the little guys to go up against Goliath, it makes me feel good about myself, because I know new lawyers, middle lawyers, old lawyers, all of a sudden are now invigorated to stand tall, because what I've taught them through my lectures and my book is the Charlie Chan line. If size were all that mattered, the tiger wouldn't fear the scorpion. And you learn the tools, you're the scorpion, and people will respect you.
That's awesome. Well, thank you so much for taking the time to come today. I've really enjoyed this.
It's been my privilege. So I will close with the way I always close, and that's my midlife crisis.
Okay.
Thank you for having me.
Thank you so much.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you're a regular listener, be sure to visit our website, www.triallawyernation.com, to opt into our mailing list and stay updated on our new episodes. And if you have a Facebook account, send us a request to join our private group called Trial Lawyer Nation-Insider Circle. This exclusive group will allow you to hear about our podcast before they air, interact with the show, and get a sneak peek at some of the behind-the-scenes moments. If you're not on Facebook, you can always contact us via email at podcast@triallawyernation.com. I love to hear from all of you, so please continue to send us emails. Thanks for tuning in, and I look forward to having you with us next time on Trial Lawyer Nation.
Trial Lawyer Nation, in partnership with Trial Guides, leader in continuing education for civil plaintiff and criminal defense trial lawyers, with books, DVDs, CLEs, live webinars, and more. Visit trialguides.com and use code 30B619. That's 30B as in beta 619 at checkout to receive 10% off Mark Kosieradzki's products. This Trial Lawyer Nation discount includes 30B6, deposing corporations, organizations, and the government, and Anatomy of a Personal Injury Lawsuit. This discount expires August 31st, 2019. We look forward to talking with you again soon as we continue to explore powerful insights from our amazing host and remarkable guests here on Trial Lawyer Nation. Until then, please be sure to subscribe and review this podcast on iTunes or your favorite listening app, so we can continue to reach more listeners. Visit us at www.triallawyernation.com to send us a message, listen to previous podcasts, or learn more about Michael Cowan and our guests. This podcast has been hosted by Michael Cowan and is not intended to, nor does it create the attorney-client privilege between our hosts, guests, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.